ex and I have joint custody, but he hasn't been letting me exercise custody and see the child for a couple of months now. Will he lose custody if I go back to court and expose this? This is a good question that comes up frequently. I'll assume that what you mean by my ex and I have joint custody is that you and your ex share some kind of joint custody of your child. I'll also assume that in the past couple of months, while you have made reasonable efforts to follow the court-ordered custody schedule, your ex is interfering with those efforts by refusing to send the child with you when you knock on your ex's door, for example, to pick up the child, or by getting to school before you do and snatching the child up and racing away before you can pick up the child yourself at school. Shenanigans like those. The laws governing the enforcement of child custody orders and the modification of child custody orders may share some similarities, but are not the same, so you will need to ensure you understand what the law is for your jurisdiction. This is Utah Family Law TV, so we talk about Utah law. Generally speaking, though, interfering with custody for merely a couple of months won't be enough to get a court to strip the offending parent of whatever custody rights and schedule was ordered. To modify the child custody award in Utah, where I practice divorce and family law, the parent seeking the modification must show that circumstances have changed so substantially and materially that the best interest of the child necessitates a modification of the custody schedule. The court would likely find the offending parent in your situation in contempt of court for violating the custody schedule orders for that couple of months that he violated the orders, and then penalize that parent with fines or awarding you your attorney's fees incurred in pursuing the contempt motion. It might also include community service hours for the offending ex-spouse or attending parenting courses and perhaps even imposing a jail sentence. The court would also likely award you make-up time, additional time for you and the child to spend together over and above the court-ordered schedule to compensate for the time your ex deprived you and the child of spending together. And it's good that you are looking into this now, because if you don't take action to enforce the joint custody order and the time you and the child are to spend together, and continue to permit your ex to deprive you and the child of your court-ordered time together, that could actually be used against you as evidence against you for modifying the custody award so that you lose joint custody or have less time with the child and become relegated to a minimal visitation or parent time schedule.